Okay, welcome back, class. We are now going to discuss part one of obligation. I'm your coach, your moderator, Attorney Lyndon Maceren. Welcome back. So, what we will expect from this class today is we will learn part one. So, it contains the definition or the general provisions of obligations, sources of obligations, essential requisites, the nature and effect of obligations, and part two, part three will be discussed in a separate video. So today we'll discuss this area here, part one of obligations, including its nature and effect. So let's start with defining obligations. In Article 1156 of the Civil Code, it gives us the definition of obligation as a juridical necessity to give, to do, or not to do. So there are three kinds of obligations: to give, to do, or not to do. In a different definition given by Arias Ramos, which was recommended by Supreme Court Justice Reyes, obligation is defined as a juridical relation whereby a person may demand from another who is the debtor the observance of a determinate conduct. And this conduct is the giving, doing, or the not doing. And in case of breach, so breach is the non-observance or non-compliance of the terms and tenor of the contract or the agreement. You know? So in case of breach, the creditor may demand satisfaction from the assets of the debtor. So if the debtor has assets, then he may recover damages from the assets. So what is juridical necessity? It is something that if the obligor or the debtor, the obligor or debtor are the same, obligor or debtor cannot comply with the obligation, then the creditor or the obligee may enforce or can enforce his right to compel compliance or performance in any court of law. So juridical necessity is very important. Without it, the creditor cannot go to court. I'll give you an example later. So examples of civil obligations. To give. To give is a real obligation because you must understand that giving is a real obligation. Now, obligation to pay student her school tuition. So that is an example of a real obligation or to give. So the obligation of a student to pay her school tuition. So that is the first example. An example of to do is or personal obligation. So to do is a personal obligation. The obligation of parents to take care of their children. Is this embodied in a law? Yes. There is a law that mandates every parent to take care of their children. It is in the family code. So if the parent cannot take care of the children, then the state will require the parent to pay damages, or sometimes they will be imprisoned. No? The third one is not to do. This is a negative personal obligation. Example of this is an obligation of every citizen not to commit a crime. So committing a crime, one will go to prison. So This is a negative personal obligation, not to commit a crime. What is the juridical necessity here? The juridical tie is the law, again, the criminal law. So to give is a real obligation, to do is a personal obligation, not to do is negative personal obligation. So in these examples, the creditor, in the first example is the school. The second example is the state, and the third example also the state are the creditors. No, so the creditors, if may compel the debtors to comply with the obligation in any courts of our land. So pwede sila magkiha. Because non-compliance, not compliance or non-fulfillment gives the creditor the right to demand from the debtor fulfillment obligation in a court of law. Okay. So what are those kinds of obligation which has no juridical necessity? So these are what you call the moral obligation and natural obligations. No? So without any juridical necessity, the creditor cannot or has no right to demand from the debtor performance of the obligation in a court of law. Okay, what's the first one? Moral obligation. What's that? Obligation to attend Sunday masses. Can the church comply or go to court in order to comply the devotees to attend masses every Sunday? No. So there is no juridical necessity in this moral obligation, as well as natural obligation. What is this? Obligation to pay back a debt of gratitude. So, utang na loob, no? So if you have a debt of gratitude, let's say, for example, to your parents, because they're the ones sending you to school, they're the ones giving you food, shelter, clothing ever since you were a child, up to the time that you have already stand on your own. So, do you have are you compelled to pay that debt of gratitude? The answer is no. So your parents cannot go to court to compel you from repaying your debt. So that is, and these are examples of obligations which don't have juridical necessity. So in an obligation, there are requisites. So first, I will give you an example of an obligation. Eve promised to repay her loan to Mario, the amount of 10,000 pesos. So she is indebted to Mario the amount of 10,000 pesos. So what is the juridical tie here? There is a loan. Loan is a kind of contract. So there's a contract existing between Eve and Mario. So the first elements are the subject persons. So first person is the passive subject. Passive subject is the one who has the obligation to give, or in other words, the obligor or the debtor. Yeah? So who is the obligor in this case? So it's Eve. No? Eve is the passive subject. And the second subject person is the active subject. Active subject is the same as obligee or creditor. And in this case, it's Mario, because Mario is the one who has the right to demand from the debtor. So these are the subject persons, passive subject and an active subject. So every obligation must have subject persons. There must be a passive subject and there must be an active subject. If these two are not present, then there is no obligation. Second uh, element or requisite of obligation is that there must be an object. So in this case, the object or subject matter or prestation is the 10,000 pesos. Here, 10,000 pesos. And number three, requisite, is that there must be legal or juridical tie, which is the efficient cause. So in this case, the source of obligation or the juridical tie between Eve and Mario is the contract of loan. No? So the sources of obligation under Article 1157 are the juridical ties, which is law, contract, crime, or quasi-contract, quasi-delict, and in this case, the contract. So without these three present, actually four, because there are two subject persons. Without these four present, one, two, three, four, there is no obligation. So what are the requisites in order that the object or prestation is valid? No? First, the object must be licit or legal. Otherwise, if it's illegal, then it's void. There can be no obligation if the object is illegal. Like I'll give you marijuana or I'll give you shabu. Those kinds of things are illegal, so there is no obligation. Second, it must be possible physically and juridically. Otherwise, it is void. So example, Ami obliged to give Matt a baseball bat for 500 pesos. So this is valid. No? So Ami will give Matt a baseball bat and Matt will give 500 pesos. A void example is when Ami promised to build Matt a house in the Pacific Ocean. So how can it be physically possible for Ami to build a house in the middle of the Pacific Ocean? That's physically impossible. So that's a void obligation. The third element or requisite of obligation that it must be determinate or determinable. Otherwise, void. So what is a determinate or specific object? So determinate is one which is identified by its individuality, meaning it is unique. No? So it is, you can specifically identify the object. Unlike generic, you cannot identify the object. An example of generic is a car. No? Say my car is, if you say my car is in the parking lot of CITU. So that's generic because there are several cars parked inside the parking lot of CITU. But if you say my car is a Toyota Fortuner, white color with plate number CD0222, then that is already determinate. Yeah? So the thing must be a determinate object. The fourth requisite that it must have a pecuniary value. Pecuniary value is also known as the juridical tie that binds the parties or the cause why the obligation exists. So juridical tie is the source, no? So this will be explained later.